Hey guys, Happy New Year's. I hope this video finds you well, and I hope this New Year is treating you well, and I hope you have success and prosperity for the months and weeks to come. The purpose of this video is not to promote violent extremism or criminal elements in criminal organizations. The purpose of this video is to be informative and to spread knowledge about insanity defenses. This is a request video, and I am fulfilling that request to do a video about insanity defense. This video was asked in light of current events. So as we know, on December 9th in New York City, it was announced that a person of interest has been apprehended in Altoona, Pennsylvania. On December 10th, at an outburst in front of the courthouse before a court proceeding, the person of interest shouted, "It is completely out of touch and is an insult to the intelligence of the American people in their lived experience." Then, on December 19th, 2024, the person of interest waived extradition and was sent from the Commonwealth of Pennsylvania to the state of New York in a highly publicized perp walk where the mayor may have made statements that could potentially jeopardize the prosecution's case, and also his presence there as the mayor of New York City, Eric Adams, was criticized for being unusual. And on December 23rd, 2024, the eve of Christmas Eve, the person of interest was in court at an arraignment where he pleaded not guilty, and his lawyer, Karen Agnifilo, stated that the mayor's statements on the perp walk may jeopardize her client's right to a fair trial, and that she also has double jeopardy concerns. This video is not an endorsement nor an opposition of the person of interest. It only seeks to explain. It is simply educational and informative. With that being said, let's start our video. Insanity. Defendants who were legally insane at the time they committed a criminal act aren't morally blameworthy, as explained below. Why does the law allow a defendant to be found not guilty by reason of insanity? The insanity defense is based on the principle that punishment for serious crime is justified only if defendants were capable of controlling their moral behavior and could appreciate the wrongfulness of their behavior at the time the crime was committed. Legally insane defendants who suffer from a mental disease aren't immoral actors or aren't in control of their actions. The reasoning goes, and so shouldn't be criminally punished for acts committed because of their insanity. The insanity defense remains controversial. Though the insanity defense was recognized in England as early as 1505, it remains controversial. Many people point out that a person killed by an insane person is just as dead as one killed by someone who is sane, and as such argue that people should be punished for the harms they have caused, regardless of their mental functioning. Opponents of the insanity defense also doubt the competence of psychiatrists, judges, and jurors to determine after the fact whether someone suffered from a mental disease at the time of the crime was committed, and the connection, if any, between mental disease and the commission of crime. Perhaps due to popular dissatisfaction with the insanity defense, few defendants actually rely on it. And of the defendants who do, very few are actually found not guilty by reason of insanity. What is the common definition of insanity? The most popular definition is the Manhattan Rule, established in England. In the 1840s, under the Manhattan Rule, defendants are not guilty by reason of insanity if at the time of a crime they were inflicted with a mental disease that caused them not to know that they were physically doing, lack of cognitive capacity, or not to know what they were doing was wrong, lack of moral capacity. Now, states have the power to adopt their own insanity definitions. Clark versus Arizona, U.S. Supreme Court, 2006. For example, a state might recognize only the lack of moral capacity aspect of monotony. In such a state, defendants would be sane under the law if they understood that their actions were wrong. 9 insanity defense myths. Professor Michael Perlin has described 9 myths that people tend to believe about the insanity defense, but that social science researchers have proven to be totally without foundation. The insanity defense is overused. It is rarely used. The insanity defense is used only in murder cases. Roughly 1/3 of the cases in which an insanity plea is entered involve a murder charge. Defendants risk nothing by pleading insanity. Defendants who plead insanity and are found guilty, in other words, defendants who try but fail to show they are legally insane, serve significantly longer sentences. Defendants who are found not guilty by reason of insanity are quickly released from custody. They are generally locked up for twice as long as defendants who are convicted of the same offenses. Defendants found not guilty by reason of insanity serve less time in custody than defendants convicted of the same offenses. Again, they tend to spend twice as long in custody as defendants convicted of the same crimes. Most insanity trials feature battles of the experts. About 90% of the time, defense and prosecution experts are in agreement about a defendant's mental disease or defect. Defense attorneys overuse the insanity defense to beat the rap. Attorneys often enter an insanity plea in an effort to obtain mental health treatment for defendants. Insanity is a rich man's defense. The defense is most often used in cases involving indigent, poor defendants. Defendants who plead insanity are usually claiming vague symptoms and faking it. Virtually all insanity defenses are based on schizophrenia or other specified major mental disorder. Perlin, Michael L., The Insanity Defense, 9 Myths That Will Not Go Away, 2017, for reference. Example, Bentley and Craig are charged with murder after Craig, Kills, a police officer who interrupts their attempt to rob a warehouse. Bentley's evidence shows that Bentley is mentally impaired. A head injury he suffered as a young child has left him with the mental ability of an 8-year-old. And Bentley didn't think that Craig should try to steal, but went along with Craig so that Craig would be his friend. To be considered insane in most states, a person has to be unable to distinguish right from wrong. Because Bentley knew that it was wrong to steal from the warehouse, the jury should conclude that he was sane. However, Bentley could have a partial defense. The jury could conclude that Bentley's mental impairment rendered him incapable of forming an intent to kill, so that Bentley should be found guilty only of manslaughter. Do courts use other definitions of insanity besides the monotony rule? Yes, different definitions of insanity exist, with the result that a defendant who is not insane under one definition may be insane under another. For example, another common definition of insanity accepted in some states is known as the irresistible impulse. This defense was the focus of the famous courtroom movie Anatomy of a Murder. Defendants who acted because of an irresistible impulse knew that their actions were wrong and thus would be considered sane under the monotony rule. However, they may still be considered insane under the irresistible impulse rule if at the time of the crime they were afflicted with a mental disease that rendered them unable to control actions that they knew were wrong. Are defendants who are found not guilty by reason of insanity set free? No. Defendants who are found not guilty by reason of insanity usually are confined to mental institutions and aren't released until a court determines that whatever insanity they experienced at the time of the crime is no longer present. Because judges don't want repeat performances from insane defendants, a defendant found not guilty by reason of insanity can easily spend more time in a mental institution than a defendant would have spent time in prison if convicted of a crime. Can defendants be found both guilty and insane? Yes, some states follow a guilt-first procedure. In these states, a defendant's insanity isn't determined until after a defendant has been found guilty of a crime. Then, if a defendant is found to have been insane when the crime that gave rise to the conviction was committed, the defendant is placed in a mental hospital. When and if the defendant's sanity is restored, the defendant goes to prison to serve any remaining time on the sentence. Does an insanity defense require testimony from a psychiatrist? In almost all cases involving insanity, yes. When a defendant enters a plea of not guilty by reason of insanity, a psychiatric expert determines the defendant on behalf of the defense. One reason for this is that nearly all insanity tests that courts employ require a finding that the defendant suffered from a mental disease or defect. Whatever other elements may or may not be required. The psychiatrist's investigation will normally include circumstances of the crime, the defendant's past history, and one or more personal interviews of the defendant. The prosecutor can, and usually will, require that the defendant be examined by a government psychiatrist. As myth number 6 in the sidebar above suggests, prosecution and defense psychiatric experts often agree on the basic question of whether a defendant has a mental disease or defect, but psychiatric diagnoses are to some extent subjective, so disagreements between prosecution and defense experts can be unfairly cause some people to doubt the reliability of psychiatric evidence. Competence to stand trial. Whether or not a defendant pleads insanity as a defense for criminal charges, an issue can arise as to a defendant's sanity at the time of the trial. Defendants can't be put on trial if they suffer from a mental disease that prevents them from understanding the proceedings and assisting in the preparation of their defense. If a defendant claims incompetence to stand trial, a judge will hold a hearing and take evidence concerning the defendant's current competence. Insanity refers to a defendant's mental condition at the time the crime was allegedly committed. Competence to stand trial evaluates a defendant's mental condition at the time of the trial. At this hearing, the defendant has the burden of proving incompetence to stand trial by preponderance of the evidence. Cooper v. Oklahoma, U.S. Supreme Court, 1996. If the judge decides that the defendant is mentally incompetent, the defendant will probably be placed in a mental institution until competency is reestablished. And what the U.S. Supreme Court has said are likely to be rare circumstances. Prison officials can legally force prisoners to take medications that will make them competent to stand trial. Sell v. U.S. Supreme Court, 2003. Once a prisoner regains competence with or without the help of medication, the trial will take place. Defendants can be mentally competent to stand trial, yet not sufficiently mentally competent to represent themselves. Indiana v. Edwards, U.S. Supreme Court, 2008. One good but extreme example of how competency to stand trial works involved the alleged mob boss, Vincent the Chin Gigante, who was indicted for a variety of crimes including murder, mail fraud, and extortion. Gigante claimed that he was incompetent to stand trial, based in part on evidence that for years his life consisted only of wandering around the block he lived in pajamas and a bathrobe. In 1996, a federal judge ruled that Gigante had engaged in an elaborate deception for more than 20 years and ordered him to stand trial. Gigante reportedly told other mobsters that pretending to be crazy just wasn't worth it. However, while opposing psychiatrists may disagree about whether a defendant suffers from a mental disease or defect, Federal Rule of Evidence 704B prohibits psychiatrists from testifying directly that a defendant was either sane or insane. friends and relatives as defense witnesses. Jurors tend to be suspicious of defense medical experts who pronounce a defendant insane based on a conversation or two and a review of records. The strongest evidence of insanity is often provided by friends and relatives who have known the defendant long enough to form a reliable opinion that the defendant is mentally ill. Most jurisdictions allow non-expert witnesses to give an opinion regarding the sanity of a person with whom the witness is well acquainted. Can judges appoint psychiatrists to examine indigent defendants who rely on an insanity defense? Yes, an indigent criminal defendant who claims to have been insane at the time of an alleged offense and whose sanity is seriously in question is entitled to the assistance of a qualified mental health expert, typically a psychiatrist. The defense mental health expert must be independent from the prosecution. The defense expert's role is to assist in evaluation, preparation, and presentation of the defense case. McWilliams versus Dunn, U.S. Supreme Court, 2017. The partial defense of diminished capacity. Diminished capacity is a partial defense akin to insanity. Where it is allowed, diminished capacity can reduce the criminal responsibility of defendants whose acts are the result of mental defects that fall short of the legal definition of insanity. Diminished capacity played a central role in the important California trial in the early 1980s when a jury accepted a diminished capacity defense and convicted Dan White of manslaughter for KILLING San Francisco Mayor George Moscone and Harvey Milk, an openly gay county supervisor in San Francisco. White relied on the so-called Twinkie defense, claiming that eating hot food high in sugar content left him temporarily unable to control his action. The verdict so aroused the public anger that California and other states abolished the diminished capacity defense. Does the defense bear the burden of proving insanity? Usually, the prosecution will still have the initial burden of proving guilt beyond a reasonable doubt. But after that, defendants wishing to raise an insanity defense in most states and in federal court will have the burden of convincing a judge or jury that they meet the requirements of their jurisdiction's insanity tests. Normally, the defendant's burden is to prove insanity only by a preponderance of the evidence. The lower burden of proof commonly used in civil cases. However, some jurisdictions make things harder for defendants by requiring them to prove insanity by a clear and convincing evidence. A burden of proof somewhere in between the lower preponderance and the higher reasonable doubt standards. Does the defense have to notify the prosecution before trial that it will present an insanity defense? Yes, as with the alibi defense. Pre-trial rules in many jurisdictions require defendants to advise prosecutors prior to the trial that they will rely on an insanity defense at trial. See Federal Regulation Criminal Penal Code 12.2. Prosecutors often respond by demanding that a defendant be examined by the government psychiatrist before trial. What is the connection between XYY syndrome and the insanity defense? The XYY syndrome is a chromosomal abnormality that results in some men, estimated at 1 in 1,000 men, having an extra Y chromosome. It is thought to produce super males who are more than likely than normal XY males to engage in criminal activity. However, researchers are uncertain about whether the extra Y chromosome causes the greater frequency of criminality. A few XYY defendants have argued that the abnormality renders them legally insane. The argument has to date not been successful, as the syndrome hasn't been proven to impair mental capacity to such an extent that a person is legally insane. Duress. Offenders may not be guilty if they commit crimes while under extreme duress. What is the duress defense? The duress defense arises from a defendant admitting committing a crime, but offers evidence that they were genuinely threatened with immediate or serious physical harm if the crime weren't carried out. In most states, the diverse defense doesn't extend to killing innocent people. Example, Bob Alou is standing at a bus stop when a gun is pressed against his temple, and he hears a man whisper menacingly, "You are a DEAD man right now unless you grab the purse of the one lady standing next to you and hand it to me." If Bob takes the purse and hands it over to the gun holder, the circumstances are probably sufficient to establish the defense of duress. Example, in the same scenario, the man whispers menacingly to Bob, "You're a DEAD man right now, unless you KILL the lady standing next to you." Though Bob is subjected to the same level of duress in both examples, Bob can't rely on a duress defense in this situation. If Bob KILLS the lady, he is guilty of MURDER in almost all states. A few states reduce the crime to manslaughter when a defendant KILLS under duress. Necessity. The defense of necessity is also known as the lesser of two evil defense. What is the defense of necessity? The necessity defense arises when a person commits a relatively minor offense in order to avoid a greater and imminent peril. The defense vanishes if the peril is minor and the harm is great. Example, Pam panics when her younger son's flu symptoms suddenly become severe and she can't get through to a 911 operator. She drives her son to a hospital's emergency room, even though a judge had previously suspended her driver's license for failure to pay parking tickets. Pam can invoke necessity as a defense to a charge of driver with a suspended license. Example, Honus Wagner realizes that he dropped a cherished baseball card on a section of a railroad track. To prevent a rapidly approaching train from destroying his card, Honus shoves a large rock onto the tracks. The train hits the rock and derails. Many passengers are injured. Honus can't rely on the necessity defense because the gravity of the harm to the train and its passengers is huge compared to his threatened loss. Is necessity a common defense? No, the defense exists primarily in the writings and musings of law professors. The necessity defense most famously arose in the 1884 English case known as Regina versus Dudley and Stevens. In this case, 4 sailors who survived a shipwreck were stranded at sea in a small open boat. At sea for about 3 weeks and without food and water for a week. They were near DEATH. 2 of the sailors KILLED, a third, and who was chosen not by a lot. The third, but because he was the youngest, also was weak from drinking seawater. The 3 remaining sailors ate his flesh and survived until they were rescued 4 days later. Charged with MURDER, the 2 KILLERS relied on a defense of necessity. The jury rejected the defense and convicted them of MURDER. The judge sentenced the KILLERS to DEATH, but the government commuted the sentence to 6 months in prison. Intoxication under the influence of drugs or alcohol. Defendants don't have a constitutional right to offer an intoxication defense. Montana versus Egeloff, U.S. Supreme Court, 1996. The voluntary ingestion of alcohol or drugs doesn't criminally excuse a defendant's criminal behavior. Is having been under the influence of drugs or alcohol a complete or partial defense to criminal charges? Voluntary intoxication is rarely a complete defense to a criminal charge. People know or should know that alcohol and drugs may affect their ability to control their behavior. As a result, defendants who voluntarily consume alcohol or drugs and because of that commit a crime are subject to punishment to the same extent as defendants who commit crime while stone cold sober. Example, Frank Lee is charged with sexually assaulting Terry Jones. Lee claims that he had been drinking heavily at a party on the night of the attack and that his mental functioning was so impaired by the effects of alcohol that he lost control and attacked Jones. Lee can escape conviction and punishment by blaming his actions on intoxication. However, voluntary intoxication may serve as a partial defense to crimes requiring a prosecutor to prove that a defendant acted with a specified intent. Intoxication doesn't entirely excuse the defendant's crime, but if intoxication produced mental impairment that rendered a defendant unable to form the required specified intent, the defendant might be convicted of a lesser crime. Like insanity, this defense must be usually supported with medical and psychiatric testimony. Intoxication defense rules vary. Rules governing the intoxication defense vary greatly from state to state and according to the charged crime. For example, a state might have any of the following rules. Voluntary intoxication can serve as a partial defense to any crime requiring specified intent. Voluntary intoxication can serve as a partial defense only in MURDER cases. Voluntary intoxication isn't a criminal defense to any charge. Example, Buckshot is charged with assault with the intent to commit MURDER. The prosecution claimed that Buck shot at victim with the intent of KILLING Tim, but missed. Buck admits firing the shot, but claimed he had no intention of KILLING Tim. Buck claims that about an hour before the shooting, he had ingested an illegal drug that so impaired his mind that he was incapable of forming an intent to kill Tim. The prosecution has charged Buck with a crime that requires the prosecutor to prove that Buck had a specified intent to KILL Tim. If because of the drug consumption Buck was incapable of forming an intent to KILL, in some states Buck could have been found guilty only of a lesser crime such as assault. If Buck could somehow prove that he was so impaired that he didn't even recognize Tim as was a person, but honestly believed him to be a deer, for example, Buck might prevail in this type of argument. Again, even when this would be allowed, where this would be allowed, as the example indicates, it is hard to prove. Can involuntary consumption of drugs and alcohol serve as a complete or partial defense to a criminal charge? Yes, people might consume drugs or alcohol through no fault of their own and lose the ability to control their behavior. If the judge or jury agrees that a defendant consumed drugs or alcohol involuntarily or because of the resulting mental impairment committed a crime, the defendant should be found not guilty. This defense conjures up images of someone forcing to drink down someone else's throat. More commonly, this defense applies when a person unknowingly consumes a drug or alcohol. For example, assume that Michelle is at a party and that servantess slips a drug into Michelle's drink that causes an intoxicating effect on Michelle. Michelle strikes and kills Marilyn while driving home from the party and is charged with MURDER. If Michelle can prove that she was unknowingly DRUGGED and her senses were impaired as a result, she may be acquitted entirely or at least convicted of a less serious crime. Entrapment. Entrapment is an I really and truly didn't want to do it defense. What is the connection between entrapment and predisposition? The entrapment defense protects someone from a conviction if a government agent, often an undercover police or a police informant, induced the person to commit a crime. However, a person's predisposition to commit a crime can negate the entrapment defense, even if a government agent suggests a crime and participates in carrying it out. A predisposed defendant's entrapment defense is unlikely to succeed. Entrapment defenses are therefore difficult for defendants with prior convictions to win. Example, solely on the basis of a statement made by a confidential informant, A police officer suspects that Hai Po is a drug dealer. Wearing a concealed recorder, the officer tries to buy illegal drugs from Hai. Hai refuses to sell any drugs and claims to know nothing about drugs. The officer repeatedly pleads with Hai to sell drugs, indicating that the officer needs the drugs to treat a medical condition. Hai says that he thinks he knows someone who can procure drugs and arranges to meet the officer an hour later. Hai returns and an hour later offers to sell drugs to the officer and is immediately arrested. A judge or jury would be justified in concluding that the officer entrapped Hai to inducing Hai to commit a crime that Hai wouldn't otherwise have committed. If so, Hai should be found not guilty. Example, same case, when the officer approaches Hai to buy illegal drugs, we could be under surveillance from the cops. The officer convinced Hai to conclude the drug deal in a secluded alley. The officer then arrests Hai. The officer talked Hai into selling the drugs, but Hai was evidently predisposed to the sale under the right circumstances. A judge or jury would be justified in convicting Hai. Does the defense bear the burden of proving entrapment? Yes. Defendants who claim that they were entrapped into committing illegal acts normally have the burden of convincing a judge or jury by a preponderance of the evidence that they were induced to commit crimes they weren't predisposed to commit. So there you have it. That explains insanity, necessity, duress, competence to stand trial, and 9 insanity defense myths. Thank you for listening. Thank you for watching. That concludes our video. Give this video a thumbs up by liking it. Feel free to comment on how you believe this video relates to the current events that have been unfolding for the past month. And feel free to subscribe, all of which help push our video past the algorithm and support this channel. With that being said, take care. I'll see you in the next video. Bye.